2457 Carolyn Barnes.
Good morning. For the record, yesterday the Board of Disciplinary Appeals convened outside of the presence of Mr. Kittner, Mr. Gonzalez, and Mr. McKetta to address the motion to recuse filed by the respondent. And after due consideration, that motion was denied.
Thank you. Mr. Taylor wants to excuse himself from this particular matter, so he'll be recused for this particular hearing only.
Well, I object that anybody who's on the board should be here while you're picking and choosing who's going to sit and who's going to be exiting. I think that's unfair. If you're on the board, you're on the board. I think you, Mr. Kittner, have a serious conflict of interest. And I don't appreciate you sitting on the board, but if I have to suffer that, I should at least suffer the whole board. You're the chairman, and I'm objecting to you.
Your objection.
So I object to anyone leaving the board for any reason.
Your objection is noted.
Mr. Kittner, I need clarification. Ms. Barnes, are you objecting to any of the 12 members of this board leaving this hearing?
Yes, I am. You're either a board or you're not a board. You either act like a board or you're not a board. I'm tired of people suspending the law when they want to. You're all licensed attorneys, and for 7 years, I have seen licensed attorneys act like this. And this is your representative who has been involved with John Bradley for 7 years. And you all know it. And you think you're not going to have what she knows imputed to you. She sat through the trial. She saw the gross violation of constitutional rights in Williamson County. She participated from May 2010 when John Bradley started this to silence me during the investigations with the Science Commission. She was involved. And she's been involved for only working in tandem with
Ms. Barnes,
John
we need to move on, so please be seated.
I have objected to your jurisdiction.
Your objection is noted. Please be seated.
I'll be accused.
You may.
I'm recusing myself.
Do we have any criminal people with criminal backgrounds here? You're letting the one criminal defense lawyer leave. Is anyone on the board have any criminal knowledge? This is what I'm talking about. How do corporate lawyers understand what John Bradley did if you have no criminal background? You don't even know.
Ms. Barnes, please be seated, and just for the record, Mr. Taylor has voluntarily recused himself. Isn't that correct, Mr.
Yes.
Taylor?
May I be excused?
You may. Let's proceed. Mr. Berry?
Okay, I believe there were two other motions. There is a motion to dismiss that Ms. Barnes filed. There were two.
She can argue that when it's her time. I want you to go ahead with your.
Okay.
We have special exceptions that would be heard first and jurisdictional objections. You see, you're not being fair and impartial. I'm entitled to due process even in this court.
Please
or
be
this
seated.
tribunal. It's not even the court.
Please be seated and let her proceed.
May it please the board.
You may.
This is a motion for entry of judgment against Carolyn Barnes pursuant to Part 8 of the Texas Rules of Disciplinary Procedure. On June the 11th, 2013, a judgment of conviction by jury, sentenced by jury to prison in Texas Department of Criminal Justice was entered in cause number 10-663-K368 styled the State of Texas versus Carolyn Barnes in the 368th Judicial District Court of Williamson County, Texas, wherein Ms. Barnes was found guilty of aggravated assault with a deadly weapon. She was sentenced to 3 years in the institutional division of the Texas Department of Criminal Justice and was ordered, she also had credit for 690 days on her sentence, and she was ordered to pay.
She is misstating fact. Is she testifying or what is she doing? I want her under oath testifying if she's representing material facts of this tribunal. that you're gonna rely upon. I want her under oath, because she's not telling you the truth, and I'm tired of it. You're gonna rely upon these facts, and she knows the truth. She was there, and she's intentionally misrepresenting the facts.
I assume that Mr. Berry will have the proper proof to support what she's saying. If she doesn't, we'll take it up at that point.
I still want her under oath.
She was also,
Please.
Opening, or is this evidentiary, Mr. Berry? Is this an
beg your pardon?
opening, or is this evidentiary?
this is evidentiary.
I want her under oath. She has personal knowledge. She was there and present. She heard it, she saw it, she knows it.
Let's put both of them under oath.
Yeah, I think that's appropriate.
Both of them?
Yeah, go ahead.
If you'll both raise your right hands. Do each of you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Absolutely.
If I may finish, she was also ordered to pay court costs in the amount of
Back up
$389.
where you told them I was convicted.
Sit down, please.
Respondent appealed this conviction under cause number 13-13-00434-CR in the Texas Court of Appeals, 3rd District at Austin. An interlocutory order of suspension was signed by this board on August the 28th, 2013. On July 13th, 2016, a judgment and an opinion were issued by the Third Court of Appeals in cause number 03-13-00434-CR, Carolyn Barnes, appellant versus the State of Texas, appelling, affirming the district court's judgment. The third court's mandate issued on February the 9th, 2017. A motion for entry of judgment of disbarment was filed with the board on February the 27th, 2017. Respondent was personally served with the motion and notice of hearing on March the 2nd, 2017 by Darrell D. Darnell, a Williamson County Deputy Constable. Proof of service of the motion for entry of judgment and of disbarment was filed with the board on March the 20th, 2017. At this time, I would offer the following exhibits. Exhibit A is the opinion issued by the Third Court of Appeals. Exhibit B is the judgment issued by the Third Court of Appeals. Exhibit C is the mandate issued by the Court of Appeals. And Exhibit D is the original certificate of Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated April 3rd, 2017, which indicates that respondent is licensed but not currently authorized to practice law in the state of Texas. May I approach?
Any objections?
Yes, I object, first of all, they were obtained by fraud and they're fraudulent documents, and you know it because she knows it. Secondly, the hearsay within the hearsay I would object to, because again, those are fraudulent documents that contain matters that do not represent the truth, and you know it because she knows it. She was there. You can't just fabricate
Let me see,
documents and
Mr.
put them in
Barrett.
a tribunal and call them admissible. They're not. And I have a right to cross-examine her on them. That's getting beyond.
Your objections are overruled and admitted.
I still
Exhibits
want
A
to
through
take the
D.
witness on board our, she's not qualified, and she's definitely presenting to a tribunal documents she knows are fraudulent and obtained by fraud.
Anything else?
Respectfully request a entry of judgment of disbarment. Thank you.
Thank you. Ms. Barnes, you have 15 minutes.
I would like to cross-examine the witness she just testified.
No, give your opening first.
I have a right to
About
cross-examine her.
jurisdiction to jurisdiction.
Call your witnesses if you have witnesses.
Mr. Barrett.
I'm going to object to testifying as opposing counsel.
Well, let's see what she's
You
going
made
to.
yourself a witness by participating. Is it not true that you started talking with Guilford Jones in May of 2010, specifically about coming after me?
Pardon me, Mr. Kittner.
yeah,
Mr.
yeah,
Kittner,
yeah.
under the rule, the material issue
I agree.
that I understand we need to address is whether there is a valid
Final judgment.
conviction, a final judgment.
Right. I agree
If
with
there
that.
are questions, was it a certified copy that was admitted?
Yes.
Or was uncertified?
No, they were certified.
I would like to hear questions, if there are any, that are material to the issue of the existence of a final judgment.
That's correct. We're not going to go into the matters that, the underlying facts or any of that matter.
So
The
you
o-
don't recognize that if a
Ma'am,
judgment
ma'am,
was
ma'am.
secured by fraud or violation of your constitutional rights, you
Ma'am.
don't still recognize it as valid. That's not the law in Texas.
Carolyn jurisdiction.
It's not the law in Texas.
Ma'am,
You have no
the
jurisdiction to do this.
issue before us is whether the underlying judgment against you, conviction, is final.
You already know it's on appeal. You already know that. I've already told you that it's up on appeal. That's not the issue here. The issue is you have no jurisdiction. People like DeBerry and John Bradley conflate authority and jurisdiction power. You may have the power to do anything you want, just like John Bradley and Mr. DeBerry. But that doesn't mean you have authority and jurisdiction. You can't conflate the two. That's hubris, and that's what I've been dealing with. They have the power to do whatever they want. They have proven it for 7 years. But they are usurping their power. They do not have authority. The Texas Government Code is very clear in 81.077. It can't get any clearer. When the legislature delegated their power to the Supreme Court, it said you may not create little internal rules like she's going by to disbar an attorney summarily. I am entitled to due process. I demanded my right to be heard in writing on June the 15th, 2010, and I challenge her to show you any time I ever waived any of my rights. They were stolen from me, ripped from me, and never had due process. She knows that Doug Shaver had no oath of office. She knows that Ferreira versus California was violated. That is a U.S. Supreme Court decision. You cannot take away my right to be heard. You cannot revoke a $50,000 surety bond because I prove you have no oath of office.
Ms. Barnes?
You cannot force a court-appointed
Barnes, we have a
lawyer
question.
to silence me.
I want to go back to the argument about jurisdiction. And you're right, in the plain text of the government code, it talks about felonies involving moral turpitude.
And that's the jury issue.
And so what I'd like you to address for us, and whether you prefer to do it from your chair or from the lectern, is the response is the Code Construction Act says that we look for the statute that was actually amended a bit more recent in time versus what the statute you're claiming is. Would you address that, please?
No, this is the trick you've played with moral turpitude. This was not a crime of moral turpitude, and that's why she and John Bradley and Robert McKay did all that finagling. If you know criminal law, you cannot have a deadly weapon finding unless you show during the commission of a felony there was a use or display of a weapon. Look at the indictment. It says what the law says, felony. The game they played on February 28th of 2011 when I proved the judge had no oath of office, and John Bradley and Robert McKay did a nolle prosequi and completely gutted the indictment. They didn't realize when they gutted the indictment of the part they couldn't prove and said it was superfluous when it was the heart of the indictment that made it a felony. The court no longer had jurisdiction. The problem is when I proved the judge had no oath of office, he got mad, revoked my bond, threw me in jail, and they forced a court-appointed lawyer on me that John Bradley got to pick. She wouldn't investigate all the complaints we filed
The elements,
against Alan Schreiber.
elements of moral turpitude.
When they got it and amended the indictment, took that out, they were only, and he says it on the record, were only alleged an assault by threat. That was the problem they had. When I came back and filed my motion to dismiss, you no longer have jurisdiction because an assault by threat is a Class C misdemeanor. And in fact, because the threat was reportedly, if you don't get off my property, I'm gonna kill you or something like that, which story changed every time she told it. That was the threat the woman and the pastor made. Now, that is a Class C misdemeanor, except if the allegation is that this is a criminal trespasser on a landowner's private property. Penal Code Section 9.04 and 9.41 says the landowner has the right to make a conditional trespass warning threat. There were signs up, no trespassing. If she were on my property, she would have to circumvent a security gate that had a big bold no trespassing sign. She would have to trespass across at least a dozen landowners for 4 miles of coming in trespassing. You cannot take a non-threat in that situation. It's not a Class C misdemeanor if you're alleging I'm a landowner and you're alleging she's a trespasser. It's no longer even a Class C misdemeanor. Merely exhibiting or displaying a deadly weapon when you're engaged in a non-crime doesn't make that a second-degree felony. When I filed my motion to dismiss, they knew they had a problem, but they couldn't go back to a grand jury and get a proper indictment.
Jack, she's talking about the underlying case, and we're here on a motion for entry of judgment, the jurisdiction of this board.
I think she's
not-
trying to respond to
Moral
Mr. Gonzalez.
interpretation.
Hold on, both of you. Mr. Gonzalez, has your question been answered?
No, I'd love to go back to the Code Construction Act.
Yes.
And if you could just help me understand the difference between their response and your argument that there's there's two conflicts about which we use.
This is why you have to be careful with people like this.
No,
Because read her response. I read it and I went, do people really think like this? Her response was that 81.077 didn't apply, that 81.07 applied. And I'm like, are you kidding me? Read 81.077 and 078 together as they're written. It's very clear. You cannot do what she's doing.
Ms. Barnes, Mr. Gonzalez was asking about the 1991 legislation 4 years after the statutes you relied on, 82.078 D as in David. Are you ready to respond about 82.078?
You can't retroactively apply that.
The legislature
Just
adopted
like-
that statute in 1991. Do you have any contentions why that should not be applied?
You cannot disbar an attorney by claiming there was moral turpitude when there was not. That is the fraud they have been running. Just like if you look in her pleadings, she just testified to under oath, she conflicts it again.
You filed briefs in the Supreme Court making that argument, and that was rejected, was it not?
No, I never, that was the point of Freda that you know because she knows.
And then you filed a motion for
I was not
rehearing.
allowed, no.
Hold
Y'all
it.
disbarred me on February 28, 2011.
Ms. Barnes.
I was never allowed to be heard, and I had a court-appointed lawyer forced on me in violation of Freda versus California.
Ms. Barnes, listen
You cannot
carefully.
force a court-appointed lawyer on someone.
You're not answering my
Silence
question.
them.
My question is this: did you not file handwritten briefs in the Texas Supreme Court that are matters of record available online and in the files of the Supreme Court,
What are you
making
talking
these
about? I have
arguments
filed writ of
that
habeas
were
corpus, appeals,
no,
be
appeals
more
from
specific.
Ms. Barnes,
appeals from the
please.
BODA decision, and the Supreme Court rejected your arguments, and you filed handwritten
Oh,
motions for
please.
rehearing, and those were rejected, were they
Oh,
not?
please, we're gonna hold someone in prison, no files, no access to the library, nothing. We're gonna run in and do this little underhanded crap, convince BODA, whoever that was, because I wasn't allowed to be there. I really liked the order that said Ms. Barnes was noticed but failed to appear. Like, you know, I'm sitting in the penitentiary of a crime I didn't commit because of this type of crap going on in the practice of law that y'all won't do anything about.
The
You
question
won't
was
do
about the
anything about
Supreme Court.
crap.
Carolyn,
The question was about the Supreme Court. Did the
What?
Supreme Court not deny each of your motions for rehearing?
It is not moral turpitude. A jury would never find that was moral turpitude. They again went on her allegations, just like Jeff Rose in his opinion. That was never in the indictment. I was never indicted under 9.05. There was no allegation that shots were fired at her. She never said that. She continues to say it. Jeff Rose says it. Why? Because the media said it. Why? Because the prosecutor put that in the media.
Carolyn,
The
elements.
witness never said that, even though she was paid over $5,500 that was never disclosed from misappropriated state funds, even though she was taken out to my property while I was being held in solitary confinement and tampered with. None of this disclosed to me. The fact that she had a master's degree in acting and directing, none of that was disclosed to
Carolyn,
me.
elements of
Mr.
It's
Maketa,
not moral
Mr. Maketa,
turpitude.
is your
A
question been answered?
non-crime is
No,
not
but
moral
I'm satisfied.
turpitude.
Okay, thank you very much.
If you think it's moral turpitude,
Ms.
you're
Barnes.
saying every
Ms.
form
Barnes.
out there that tells someone if you don't get off my property, I'm gonna kill you when you're trespassing, then that's moral turpitude. That's what you're saying. She is twisting around, just like the prosecutor had to do.
elements, mens rea.
There is, I briefed moral turpitude. It is not moral turpitude. Matter of fact, y'all had a lawyer in San Antonio that actually shot a process server in the back, and y'all said that wasn't moral turpitude. He gets full due process. He got full due process. From day one, I've never had due process. I didn't get to have my defense put it in trial. I didn't get to call my witnesses. I didn't get to confront the perjury. On appeal, Jeff Rose again. Jeff Rose had blocked every one of my appeals for over 5 years.
Ms. Barnes, hold on just a second. Do we have any other questions from anybody on the board?
No, Mr. Chair.
And within 4
Okay,
days of
Ms.
me filing a
Barnes.
motion to
Ms. Barnes.
recuse, he filed a retaliatory opinion.
Thank you very much.
You can't deny someone due process like you are. You do not have jurisdiction.
Thank you, Ms.
You
Barnes.
have no jurisdiction, no
Please be
authority.
seated. Please be seated. Mr. Berry, do you have anything else you want to offer?
Well, at this time, I just respectfully request that the board deny her motion to dismiss or transfer venue.
Thank you
And
very
I
much.
still renew my request to cross-examine Mr. Berry because she knows the documents she put in are fraudulent and the testimony she presented to the board was not truthful. And I have the letter from Hope, State of Texas, Hope Andrade, proving again, which she's been served many times, as have y'all,
Do
Supreme Court.
you have anything else you want to offer from an evidentiary
Yes.
standpoint?
Yes,
What-
Doug Saber had no oath of office. It
Why don't
is
you
not
mark it
a
in?
valid judgment.
Why don't you mark it and we'll take a look at it.
Mr. Kittner,
Yes, ma'am.
if you don't mind, I'm the legal abuse syndrome,
Sorry, I can't hear you.
I am the legal abuse syndrome advocate for Ms. Barnes.
Are you a licensed attorney?
No, I am not, but it is my duty as an advocate to, when she becomes triggered, it is my duty to clarify for her because she gets so triggered, it's not understandable, which I understand. In her brief, she says, in answer to Mr. Gonzalez's question, that the elements of moral turpitude are number one.
I'm going to object to Ms. Andrews testifying or arguing in this case at all. I don't think she has any certification that would qualify her to do so.
As a legal abuse syndrome advocate, I do have the right to clarify for her when she triggers. And Mr. Gonzalez, I just simply want to answer the elements of mens rea, moral turpitude, because it's very difficult for her to focus on just the issue. The mens rea, Mr. Gonzalez, is number one, an element that must be proven. So the mens rea, it must state the specific intent. The act must be accompanied by evil intent, depraved or vicious motive, or corrupt mind associated with moral turpitude. This was never brought up nor proved in the trial. It's not part of the judgment. Number two, the assault statute must require a level of harm which must be more than offensive touching. Ms. Barnes never touched anybody. Those are the two elements of moral turpitude, and neither Mr. Berry has proved them, nor the court.
Thank you. Thank you. Do you have any objection to?
I do. This is not authenticated in any way, and so I would object to it.
Response to Exhibit A is not admitted. Your objection is
That's
the
the
same.
letter I
Ma'am.
received.
I can
Ma'am.
testify to it.
The
Y'all
objection is
just
sustained.
picking and choosing, just like your jurisdiction. You have no authority, no jurisdiction, and now you're
Thank you,
picking
ma'am.
and choosing what you want to see.
Please be seated.
What you
We will
want to
take,
hear. This is just unbelievable. I would call Desi Andrews as a witness. Did Doug Shaver have an oath of office?
No, he did not.
Did we prove he had an
I'm
oath of
gonna
office?
object.
Wait.
I'll take the oath. I have personal firsthand information concerning Mr. Shaver's oath.
I'm going to object because whether Ms. Doug Shaver had an oath of office is not at issue at this hearing today. It's just whether this judgment is final.
if
The
you, and
case
that-
law is clear that he had no oath of office, the judgment's null and void ab initio. That
Ms.
is
Barnes,
cut and
Ms.
dry
Barnes.
law.
unless you have any evidence relating to the finality of the underlying judgment, we're,
A fraudulent judgment can never be final, and you know it's up on appeal. We already covered that last time.
thank you
Mr.
very
Chair,
much.
the matter,
I
I think, is
agree,
fully.
I agree. We'll take all the pending motions under advisement and advise you of our ruling. Thank you very much. You may be excused.
Thank you.